Hello everyone. Today I am doing a video on some basic topics about the forensic expert testimony. So we will be starting our video with the testimony itself and how it is divided into three phases and four main parts. The first phase involves the qualifications of the forensic expert in order for the expert to be able to render his or her opinion testimony. And phase two involves the direct examination, such as the work of the forensic expert, how it was performed, the facts, the findings that the forensic expert has obtained from the results, and from the analysis. And phase three is very crucial because it involves the cross-examination of the expert, which will usually concern the facts in evidence, the direct examination, the file, the results, the report, the laboratory, the accreditation of the laboratory. Everything is involved in the cross-examination. That is why I said it's very crucial out of the three phases. So a series of questions can be asked during these phases, such as an expert can be asked to state their name, if they were employed, and for how long they were employed, and what's the name of their company, for how long had they had the current position there, in any number of questions. So the next topic we'll be talking about is the recommendations on how to prepare for trial when the forensic expert does or does not have any kind of communication with the attorney before the actual trial. So if there is any kind of communication with the forensic expert and between the expert and the attorney, then the trial is going to go smoothly because you will have enough time and enough information to prepare for the testimony. But there are some cons to this, such as the attorneys can be too busy to discuss the case, or they might not have any kind of knowledge in the field of expertise. So you should make sure that you use some common words in order to explain the things very concisely. So that is very important. And same thing goes to the attorney, because the expert might not be familiar with all the laws and rules and regulations, the criminal processes in the courtroom. So the attorney should also ensure that they use common terms in order to help the expert understand and comprehend the processes easily. So that is the communication is the key here. And preparation for testimony without communication. If you don't have any communication, then you should make sure that you're well prepared enough in order to be able to confidently answer the questions that are being presented in front of you in the courtroom. Because everybody will be looking upon you, because you are called the expert. You're not any common man. So you're called upon in the courtroom in order to hear your expertise in the field. So you should be able to be very confident in what you say and how you present yourself. And how do you identify an attorney in a situation where an attorney can object to questions that are being asked by opposing counsel? Let's say if there is a question that is not pertaining to the case or not relatable to the case, that's when an attorney can oppose. Or let's say if the answer is already in the report that is being submitted, then an attorney can oppose the opposing counsel and be like, did you review the case already? You might find the answers, and it can be like, of course, it can be like direct, like, did you do this? Like, it has to be in a very professional manner. And how do you identify and answer compound and leading questions? So leading questions are those questions that are asked in order to get desired answers, whereas compound questions involve the key words and or, such as, let me give you an example. An example would be that a question along the lines of, did you arrive at the scene and what time was it then? Something like that. So it is complicated that is why it is called a compound question, because the question was two parts, so you should be able to answer the question very carefully and answer both the parts. So that is why it's a compound question. And so how can an forensic expert enhance their direct examination? So their ability to coordinate verbal testimony with documentation. So if you have the document in front of you, the results, so you should be able to verbally communicate the results in common words. That is the key. And also supporting opinions with admitted evidence. And this all comes with experience, like a pleasant demeanor, your professionalism, the way you present yourself. And the identification of the goals of opposing counsel for cross-examination could be, it could be the attacking of factual basis for the expert conclusions or experts' qualifications, experts' field of expertise. They might ask you questions such as, does any college in the United States offer degree in the particular field of expertise? You should be able to answer that question. You should know the answer because that's your field of expertise. And how do you reduce vulnerability during a cross-examination? If you're in that setting already, you're already vulnerable to all the questions being asked. So I would say the key is to rehearse yourself. Just say, you're at home, your mom is sitting there, just say, you be my audience. Let's say this is a courtroom setting and I'm going to tell you this summary, and you tell me if you're able to understand. And you ask your mom, what did you make out of this? So if she's not able to understand anything or just part of it, just refine or rephrase your sentences and go back and then just be very concise with what you say. So being a forensic expert is a fun job, of course, but it has a great responsibility and duty because you have the burden to, free an innocent or punish the criminal. So thank you so much for watching this video.